You can start now.
Okay. Just a second. Is the screen visible again?
No, 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 not visible. It was visible.
Okay, fine. Let me try. What happened to this? Yes. Now, is this visible?
Yes, yes, yes. Yes.
Okay. I'll make it full screen first. Uh, so, good afternoon, everyone. Uh, Let me introduce myself first. I'm Smita Tiwary, and I have been working on the issues and areas of relating to migration and diaspora for quite a long time now. And I have also been teaching in University of Delhi. I am thankful to Dr. Sau for giving me this opportunity to take this very interesting class relating to human trafficking and migration. And since specifically deals with the laws, policies, and institutional responses to human trafficking, I think it's a very specialized thing that we are going to do in a couple of classes that have been scheduled over the 1 month's time. So before I start, may I request to give a brief introduction of you so that I'll also be aware about the audience that I'm going to talk to.
Good afternoon, madam. My name is Gurpreet. I am from Ludhiana, Punjab, and welcome
Okay,
to our class.
thank you.
Afternoon, ma'am. My name is Sophia. I'm from Delhi. Thank you.
Okay, hi, Sophia. Yeah.
Good afternoon, ma'am. My name is Dev Pragya, and I am from Shimla, and I am a human rights lawyer. So it's sort of related to my field.
Okay, that's great. That's great. So I think both of us may learn from each other today. I'm also looking forward for your interaction to enrich my understanding on the subject also. And so this unit, this MDI 010 is law
Madam,
policy.
excuse me, madam, voice is little low, please. Can it be little louder?
Just a second. Let me check my. Okay. Is it fine and audible now?
Yes, please. Now it's audible. Thank you,
Fine.
madam.
Welcome. So, this MDI, this law, policy, and institutional responses to human trafficking uh, and migration, and which now we are starting with the block one, which specifically talks about the law and policies. And we will be covering today unit one. I have written, but I think when you go into the block one and you see the units, they all are interrelated. So, what I have in my mind is to discuss at least unit one and two today, as time allows and as it goes in a flow. So, we'll be covering unit one and unit two today, and probably the specific country cases, which is about India and US and all. We can have the next class on it. So, today I have just limited it to the framework and the structure, that is there in terms of international and regional legal regime in combating terrorism. So, human trafficking. Human trafficking, when we say, actually, it is a form of organized crime, transnational organized crime. And it is, in fact, when we talk, it is a grave crime which takes place at the international level. And it requires a comprehensive legal framework to deal with the challenges and the problems and the threats that comes out of this uh, organized crime. But if and it is transnational in the sense that we all know that the nature of the crime is such that it does not stop at the border. It transcends border. And also, these crimes, specifically trafficking and terrorism, are of nature where there are no one agency involved. There are multiple of agencies involved. There are multiple stakeholders involved. In fact, this is the notion of non-traditional security that we have been evolving, that the traditional notion of security was completely different, which was very state centric, and the response from the state was sufficient. But the non traditional nature of security is something which is quite comprehensive in nature. That means it is including more countries, at least regional. It is having a regional effect, and at times it has a global effect. We have seen recently the pandemic. And also, in terms of response, also just one country or response is not sufficient, not enough. So what is needed? It is needed a very calculative, collaborated, international, global, or regional effort to deal with these problems. But before we go to the looking at the what are the at present existing international regional legal regimes, I would like to just discuss that what are the significance, what are the importance of these regional and international regimes that are existing. So, yes, human trafficking, we know that it is a complex problem, and because of the porous borders all over the at the many part of the world, because even to this level we have not been able to clearly demarcate border at many level. It is not just the case of South Asia or India having. In fact, we can take example of India. India is having a very porous border with Nepal. India is having porous border with Bangladesh. And for that matter, you will see that many part of the globe, at many part of the world, the borders are not very strictly sealed. Take example of America and Mexico, and we have been seeing that how all and this is also a center point where this drug trafficking and human traffickings are taking place. So this porous border has is one that makes actually contribute to the cause of the trafficking. And what is also makes the entire thing very complex is that uh, the pretentious nature of the problem, because the perpetrators usually employ coercive tactics and the false promises. So actually there is something secretive, something clandestine about the nature of the problem, because the ones who get trafficked, they are completely unaware of the situation. So the ones who are involved in the crime, they provide false promises. They give just certain kind of imagination in the name of good jobs or good employment opportunities, or in the pretext of marriages to the women trafficked persons. So the clandestine nature of the problem is such that it is very difficult to gather accurate data. And this is what I want to raise here, a point that since data collection has been problem, first let me tell you, data collection, authentic data collection, is a problem in migration in any way. You would agree with me that all the data that we have been working are close to the reality, or maybe represent a kind of contextual reality, but they may not be the exact data, and that creates problem. But when it comes to trafficking, it has some added difficulties in the form that I just mentioned now. So actually, the legal efforts that have come up, that we are going to discuss in couple of minutes ahead, basically focuses on preventing the crime, the nature of the law that has been existing at international level and also at the regional level, followed by the national agencies also. They are primarily focused on the preventing crime, so that the at the first place crime should not take place. For that there are certain requirements are there that we will discuss later. Then protecting the victims, the one who has been trafficked, protecting them is an important aspect of the legal regimes, and also prosecuting the accused, the ones who have been accused of the crime. They should be duly prosecuted by the international standard, existing international standard. So, however, it is very complex things. Migration also and trafficking, adding to that, is a very complex thing because of the so much of socio economic reality of the society, the disparity that is existing. People usually get trafficked. They get trapped into those who give them a false dreams or false pretexts. It is easy to because they know their target. Also, trafficking is not limited to, though it may be prevalent more in the labor class or those who are extremely vulnerable, but it has captured, or it has included at least all sections of the society. Also, in terms of age, it has included all age groups. So trafficking is a widespread problem. It is not limited to a specifically certain class, but definitely we know that since labor class is more vulnerable, and they are more looking into the better opportunities, and many a times they get trapped into all these. So this comprehensive anti-trafficking policies are required, as I already mentioned, to and also it should include all the stakeholders, various agencies. There is a requirement of synergy, which may give which may be effective in terms of combating trafficking. Now, if I talk in terms of why it is significant, why it is important to have international and legal regimes, it is very important to have a common understanding of the problem, because as they say that once you recognize the problem, once you understand the problem, you are almost close to solution, because figuring out problem is important. And since the world is not homogeneous, the world is heterogeneous, there are diversities of mm, there are diversities, complexities in terms of culture, in terms of tradition, in terms of regional specificity. So there may be different way at looking to the trafficking, but it is important to have a common understanding, and it is important to establish a common definition of human trafficking, because once it is established that what actually trafficking means, it would be easier uh, to have a broad political framework or legal framework to include all those practices which comes under the trafficking. So a consistent and unified definition of trafficking is very important. Second is setting minimum standard for the states. Because once uh, whether a state is signatory to a existing legal provision, which is international or regional in nature or not, it works as a morally binding, or it works as a binding in terms that, like, peer pressure, the peer group's pressure. So that way, for example, India is not a signatory of 1951 Refugee Convention, and similarly Pakistan is also not a signatory of 1951 Refugee Convention. Many countries in the different parts of the world have not done it, but definitely they have developed their own kind of mechanism to deal with such problems or situations, uh, which is more or less in alignment with the existing legal provision, international legal provision. So that is what I mean to say, that at least setting minimum standard for the states, that this is the minimum that a state is required to do, or it should be a baseline in terms of expectation from states, so that they should come up with certain legislation for victim protection. So setting up minimum standard is also equally important. Enabling joint action. So once a clear understanding of problem is there, and once a minimum standard is has been already set, a joint action is obvious next action, because a common legal architecture would enable many countries, those who are part of that legal framework, they can have joint investigation on operation, they can synergize their efforts in terms of victim protection, and also they can put effort and make efforts to reintegrate the victim, the trafficked person, back into the system or society. So this enabling joint action is a significant aspect of international and regional legal uh, regimes. Then definitely, as we know that any kind of international and regional legal or any international treaty for that matter definitely increases international cooperation, because it is not possible without that. So these legal frameworks increase international cooperation by information sharing, by various joint investigation and operation. So, and also in terms of capacity building, which means that the countries who are developed may assist developing countries in terms of strengthening their legal structure, in terms of sharing intelligence, and also in terms of developing a kind of system for protection of victim. So that kind of facilitation of international cooperation is also an important aspect. And then international and regional legal regimes also help in strengthening national legislation and policies, because a country who might not have come up with certain legislation to deal with human trafficking, or how to reintegrate, how to protect a victim, or how to reintegrate a victim back to the society, probably country might not have come up with any kind of policy. But before coming to that, any country would do a kind of looking and understanding the best practices at the global level, that what are the best practices being adopted by other countries who are who are suffering from the problem, or who are victim of this problem. So this this gives national countries a push to have that kind of national action, which can contribute to the anti-trafficking legislation, and which can also motivate a nation or a country to go for action plans which is needed and required for the same. And it can also hold states accountable, because accountable in the sense that if countries are member of certain legal framework, international or regional, they may be asked for submitting annual report about the progress relating to these anti-trafficking measures that has been taken within the country, and country may submit it to the committee or to the commission that has been formed at the regional level. So while and they may suggest certain kind of changes or improvement, or they may say that it is not enough and they really need to meet the international level or international standard in terms of doing so. So this is a kind of a coordinated approach where all the stakeholders are involved, where all the stakeholders are uh, acting deliberately and willingly to tackle the problem. So these are the important significance, these are the importance and significance of having a international and regional regime. So I'll go to the next slide. Just a second. Yeah. Now we'll talk about the international legal regimes. What are the existing international legal regimes? So as we see that the first we look at the United Nations framework, and the first that I have taken is International Convention on the Protection of Rights of All Migrant Workers and Members of Their Family, which is in short it is called ICRMW, and this was enacted or came into force in 2003. And though it does not, as the name suggests, it basically deals with the protection of the rights of migrants and their family members. So definitely does not directly deal with the trafficking or trafficked people, but it has a very significant baseline, because it is something which have a strong potential where people can fall into the trafficking route. So this is one of the important legal existing legal framework, and it basically uh, help in mitigating vulnerabilities, because it advocates for the established channel for migration and discourage irregular or uh, not non-registered migrants. So what they do, because if we know that registered migration has a certain kind of safeguards, because their routes are clear, they are taking the legal route. But when it is the migration is irregular, or the migration takes through a donkey route or any secretive route, the vulnerability is it gets multiplied 10 times more. So by focusing or advocating that the migration should always take place a legal route, or it should be like regular migration, safe pathways, so it kinds of mitigate vulnerability. Second, it also empower migrant workers, because it makes them aware about the fundamental rights, that about the rights that they possess in in the places that they have been migrating. What are the fair working conditions that one should be aware of it, and there should be no discrimination. So one should also be aware of the discrimination one is put in. So all those may be indirectly related to trafficking, but it has a strong potential. So in that sense, this empowerment of migration workers is important. And obviously, it also fosters international cooperation, because it encourages state parties to collaborate in preventing and combating human trafficking. And this collaboration basically entails information sharing and development of joint strategies and such on, that we have just discussed it all. So, in fact, under this uh, uh, protocol, there are a lot of articles that specifically deals with the various issues. I will not go into the detail of each and every article, because we do not have such a long time. We have paucity of time, so I'll just touch upon, and probably we will look at the what are the crux of the all the articles that say. If I talk about the Article 11, which specifically prohibits slavery, because slavery is one of the very important objective of trafficking. It is almost a bonded level. Slavery is ended and now it is no more existing. But in terms of trafficking, many of the trafficked people end up to being a unpaid or bonded slave. So Article 11 prohibits slavery, servitude, and force to compulsory level. Any kind of force to compulsory level is prohibited under article within this framework. Article 16 guarantees right to liberty and security of person, including protection from violence, physical injury and threats, and intimidation. Article 18 talks about equal treatment with nationals regarding employment, working conditions, and social security. So, this is one of the very important framework where the member states will have to ensure that even if they are, if immigrants population is there, it should have equality. They should have uh, ensure equality with the immigrant population to the existing nationals or citizens uh, in terms of work, in terms of work employment, or in terms of working conditions and social security, having social security. And then there is a Article 24, which prohibits migrants from expulsion, and Article 68 and 68 also talks about international cooperation in regard to trafficking. So if I look at the crux of the entire structure that the framework provides, we can say that migrants are ensured to have freedom of movement without having fear of being detained at any point of time. And because the crux of the entire article of this framework suggests that they provide protection from abuse, which is a physical safeguard and psychological safeguard, which is important. They should have fair legal process, because many times laws are arbitrary. Many times you see that laws are not pro migrant and they are pro country, pro nation, and that increases vulnerability to many folds more. Equal access to justice is also important protection. It provides or ensures important in to the migrants, so that they can have a fair hearing. It can allow them to report exploitation or abuse if they are facing, and they should not have this fear of discrimination. So uh, somehow all these going to reduce the vulnerability of from existing threat. Already existing threat has to be reduced through this framework, and this is one of the important legal framework. And then also illegal employment, because when migrants are employed off the books, they are again become vulnerable, because it becomes extremely exploitative. What else could be an objective of going off the book? Exploitation. So the framework also provides protection against illegal employment. So this is one. The second framework that I've just yeah, the second framework that I would talk about is United Nations Convention Against Transnational Organized Crime, which came into force in 2003. And this framework directly deals with the transnational organized crimes in terms of trafficking, and it is one of the effective framework in existing international framework. And if we look at in terms of the membership, according to the United Nations treaty collection data, as of February 2024, there are 147 signatories and 192 parties to it. So you see that how widespread countries have accepted this framework for the welfare and protection of the migrants, or also those who are prone to trafficked. 147 are signatories and 192 countries are parties. So the main objective of this framework is to promote cooperation among nations in order to tackle sophisticated criminal networks that cross international borders. And the convention aims to drive countries to strengthen their own domestic laws against organized crime activities like human trafficking, drug smuggling, or money laundering. So its provisions focus primarily on the protecting witness who come forward in assisting victim of crime like human trafficking. So this was the another framework. The next I would like to talk about a protocol to prevent, suppress, and punish trafficking in persons, especially women and children. So this is a key component of the United Nations Convention Against Transnational Organized Crime that we just discussed. It is a kind of a protocol, additional protocol relating to that only. But this here it is in specificity with women and children, because earlier it was in general, it was for all. But since we know that the crime against women and the nature of the crimes against children are little different. Probably women and children constitute one of the extremely vulnerable category. So the additional protocol, provides additional safeguard to women and children in this regard. And it specifically targets human trafficking by requiring countries to criminalize trafficking within their borders, take measures to protect and support victims, and facilitate collaboration between the law enforcement agencies. So here also there are a lot of articles that gives a comprehensive definition that what actually constitute trafficking involving women and children, and what are the crimes that are very specific to this category. So Article 3 provides a comprehensive definition for trafficking, which I am not going to read out. It is long one, but just to make you understand that it basically it says that the consent of victim is irrelevant when it is forced and when it is deceptive and when the coercive methods are used. So it also signals and targets the secretive or clandestine nature of the problem, because many a times the ones who are trafficked, they are completely unaware that they are into that. So this is one, because making them aware about the situation is their prime objective, so that they can put effort by themselves also to save themselves. uh, the next is mm, here, in fact, one more point regarding this protocol to prevent, suppress, and punish trafficking in persons. There are many other articles which specifically deals with the provisions related to the settlement of disputes and ratification, amendments, and entry into force. So it basically obligates states parties to criminalize and protect victims. So that is the next legal framework is Protocol Against Smuggling of Migrants by Land, Sea, and Air, which came into force in 2004. And as you see, and as the name suggests, that this also not directly deals with the human trafficking. It does not deal with the human trafficking, but it has a huge potential, because we know that trafficking is something which is very complex and also multi faceted problem, which may take any form, because smuggling or trafficking may take place at a certain geographical space, but the planning might have taken place at a certain very different place, and the funding might be coming from another third location or place. So we see that it is like very difficult to trace the it in a totality. So, what is needed to integrate it with the problems that have a huge potential where migrants can fall into trafficking route? This is one. Uh, and this framework actually play a role in combating human trafficking by tackling the smuggling of migrants, practice Yeah, a practice which is often combined with the trafficking and leaving individuals vulnerable to exploitation. So, this protocol against smuggling of migrants at any level, land, sea, or air, becomes important. It also provides a broad definition that what is smuggling of migrants and how. The procurement in whole or the part of it in terms of the legal entry of a person into a state party. So it also talks about the criminalization of the process where it could lead to exploitation. So, and again, it talks about the international cooperation, which encourages cooperation to the fullest extent possible to prevent and suppress the smuggling of migrants by sea. So we see that it also provides certain safeguard clause, because it requires ensuring the safety of human treatment of person on vessels used for smuggling. So this can protect trafficking victims transported by sea. So border measures are also equally important, because it encourages borders uh, to detect smuggling, which can also uncover trafficking in some cases. Training and technical cooperation, because it promotes training on preventing smuggling, which definitely requires a specific training, and protection of migrant rights, human treatment of migration, and this training can help and identify and assist victim of trafficking. So these are some of the provisions that has been given under this broader legal framework, which is Protocol Against Smuggling of Migrants by Land, Sea, and Air. It also play a important role in disrupting smuggling networks that can feed into the human trafficking, which we have already discussed. And I think, yeah, international cooperation and reducing vulnerability of individuals seeking to migrate irregularly, making them less susceptible to the exploitation by traffickers. So, yeah, this is one. Next, I will come to the again here is another three framework international legal regime. Well, the one is Protocol Against Illicit Manufacturing and Trafficking in Firearms and their parts and their components and ammunition, which came into effect in 2005. And it also directly does not deal with the trafficking per se, but it has a potential, or it has a danger of going through that route. So it came into effect in 2005, and by the February 2024, there are almost 52 signatories of this protocol. So it indirectly contributes in counteracting in terms of trafficking by preventing the misuse of firearms by criminal organization involved in human trafficking. So the firearm protocols indirectly deals with the human trafficking. It kinds of hinder access to the firearms. It enhance investigation and prosecution, and also it supports international collaboration. The next legal framework is Convention on the Elimination of All Form of Discrimination Against Women. Again, and it came into force in 1981, and we see that this is also very specific to the women, the gender, because gender dimension is adds vulnerability to human trafficking. Uh, this this convention has a important role in bringing women into focus within the human rights concern. It in spirit actually it aligns with the UN goal of redefining faith in fundamental rights, human dignity, worth, and gender equality, and all those human UN sorry all those UN provisions relating to the human survival, human rights, and also women right. So basically article 6 of this convention talks about that state parties to take all suitable action, including passing of laws to stop all form of trafficking of women and exploitation of women through prostitution. So it directly, because we know that women trafficking has many dimension. At one place they may be trafficked for to work as a slave or as an unbonded labor in the houses as a house help. But one of the very significant aspect of human women trafficking is relating to the sex trade or prostitution. So it directly talks about it, and it requires countries to have ratified the convention to enact measures and legislation which is aimed at trafficking of women and ending the use of prostitution to take advantage of and abuse of women. So this it actually it encourages states to take certain concrete steps to using their lawmaking powers to combat these violation of women's right. So this is another legal framework specifically talking about women. And this one, the optimal protocol to convention on the rights of child on the sale of children, child prostitution, and child pornography. So this is a convention which was adopted in 2002, but this is again an extended protocol of 1989 Convention on the Rights of Child. So 1989 Convention on the Rights of Child is already established a UN framework, legal framework, which provides extensive protection to the children. But in terms of trafficking and in terms of using children in this specific framework. This protocol has been adopted in 2002, and so far it has been most far-reaching international legal tool for advancing and protecting children's right and shielding children from trafficking, sexual exploitation, and other kind of physical and mental abuse. So collectively, these arrangements basically employ the international community's effort or their approach to tackle such criminal violations against children. So, by if we look in terms of membership, by February 2024, almost 121 countries are signatory to this protocol, and 178 have become party to it, demonstrating that there is substantial global commitment to its aim and objective and preventing the scale of sexual exploitation among children are prevalent. So a wide range, almost more than two-third of the globe is almost party to it. So it also gives a picture that how much widespread this problem has been at a global level. So these are the legal framework. Next, when the next one is, just a second. The next one is which talks about the International Labor Organization Convention and protocols. Because labor organization conventions, that it all start, as we mentioned, that though trafficking affects wide population of country, but it is more specific to the labor class. It is more specific to the ones who are vulnerable and who are vulnerable for their survivalhood. So International Labor Organization has certain protocols relating to that. The first is the Forced Labor Convention of 1930. It is a fundamental instrument which has been adopted by the International Labour Organization to combat forced labor practices, including human trafficking. So, human trafficking is very clearly included in it in the broader framework of forced labor. And because trafficking also takes place for this exploitation of labor, so it is inherent, clearly inherent in the broader structure of it. uh, the convention, as I already mentioned, that it came into force 1930, and by 2 February 2022, it has 181 uh, member states who has already ratified it. That means signatory, 181. So if we take at a global countries, 200 or something, which is a member of United Nations, see how vast majority of countries have already joined it. Um there are a lot of articles that specifically deals with the issues related to the compulsory labor or forced labor issues, and how a state should work in terms of bringing them back from the situation of vulnerability. But however, I'm not going again into the detail of the articles. But the protocol provides a very robust protection to the labor regarding that. Uh, the second one is the Protocol of 2014 to the Forced Labor Convention 1930. So, as we see that the Forced Labor Convention 1930, which was definitely very old, and the nature of the labor, the requirement, and the magnitude of migration, it all has dramatically changed over the years, since almost like it's going to be almost 100 years. So the globe has changed dramatically. So definitely looking at the new threats, looking at the new ways of exploitation, the protocol of 2014 subsequently adds to existing protection of forced labor convention 1930, and it has been ratified so far by 60 states. uh, 60 states, and actually, it explicitly reaffirms the definition of forced labor established in the Forced Labor Convention, and it encompasses the situation involving coercion or threat that can be linked to human trafficking practices. So the definition directly involves now human trafficking also. Uh, it basically provides a provision for raising awareness, because yeah, as we have also discussed, is being aware of the problem almost solve half of the problem. So raising awareness among the vulnerable group so that they do not get fall into the traffickers. That recently there were a lot of conversations and discussions relating to the undocumented migrants or irregular migrants, that how should they be trained first within their country, and they should not take a donkey route and fall trap. So all these provisions, to make them aware, so there are a lot of training programs that are now coming up by the government agencies, also by many of the civil societies, who are trying and making the migrants who are needy and who wants to migrate from one place to another place. Because also when we talk about migration and relates it to the trafficking, we should be aware that migration within the country, within the border, is relatively easier, and probably there exist many routes, many mechanisms that one can be resilient enough and fight back and come to the normal system. But the problem adds on when one crosses international border, and the problem of trafficking is attached to the phenomena one when actually crosses the international border. So making aware those people who are going to cross the international border by any means, fair, regular or irregular, they should be aware of it all. Strengthening the enforcement, in the sense that ensuring relevant legislation covers all workers and all sectors, and there should be labor inspection services who can monitor the condition of the labor. So it is important to save them from falling vulnerable, becoming more threat prone. And then protecting migrant workers in the time of exploitation, during recruitment or placement, or maybe at the time of crisis. Because at the time of recruitment also, migrants are vulnerable from day one, because when they are expecting to be recruited, they have to they have to agree on certain conditions to the middlemen, which may be exploitative in nature, in terms of money or in any other terms, in any other possible terms. So, and also in terms of the placement of their choice, the places which they are willing to go because of their certain kinship or the closeness of the community. And also in terms of crisis, like we saw that how during the time of pandemic and corona, wage theft, a very bad working condition for the migrants, we all have seen that. So this is kind of provides protection in the time of crisis as well. Identification and support for victim, it is important to have a clear identity and also a support system for the victim, those who are going through that process. And then rehabilitation process for the forced labor, including those trafficked and for the labor purposes. So how to bring them back from the trap, and how to ensure the rehabilitation process of those into the normal society or back to the system. So this is also provides extensively. Then I'll talk about the next, the abolition of forced labor convention 1957. This abolition of forced convention 1957, it is a crucial instrument in the fight against forced labor, including uh, arising from the human trafficking, those forced labor which is the result of human trafficking. So it came into effect in 1957, 57 and 59, because 57 it was proposed and 59 probably it came into effect. It's written 57 here. And it has been so far ratified by almost 178 states. Uh, it also talks about the forced labor, but indirectly it deals with the human trafficking as well. So it provides a broader framework how to eliminate forced labor practices, and which is highly relevant to the human trafficking context also. The then again there are certain provisions and articles which are long in nature. I'm not going to read it, I'm just going to give a crux of it, that it similarly it also talks about the same thing, that wide range of definition of what constitute forced labor, and also what are the means and coercion of uh, the forced labor, by what means forced labor laborers are being created, and what are how coercive they can be. So this is also being discussed, and it addresses situation where individuals are trafficked for the labor exploitation to fulfill some economic specific economic purposes also. So this is abolition, it's complete abolition of labor convention. um, it also focuses on the state action, that because state is a primary member of the legal framework, all international treaties or regional legal regimes relies on the national action at the end, we know that. So it also basically focuses on the state action that and ensures in a form of obligation of the member states to abolish forced labor and address human trafficking requirement at the border, collaboration with the other government, and also involve various other stakeholders like civil society organizations and private sectors. So it is a significant instrument in the global fight. Then the next is ILO Convention of 182 on worst form of child labor. It also specifically talks about, which has been adopted or enacted in 1999, and it is specific to the child labor as a critical point, and it is a legally binding agreement that addresses child trafficking and exploitation. uh, it specifies the worst form of child labor, which includes all form of slavery, children trafficking, debt bondage, serfdom, forced labor, compulsory recruitment of children in the armed conflict, child prostitution, pornography, illicit activities, and work likely to harm children's health, safety, and morals. So this is a wide range of definition that has been adopted by ILO convention, and it includes broadly all sort of crimes which has been categorized as a worst crimes again of child labor. And the ratifying states need to eliminate the child labor as a matter of urgency, because you know that the child labor provisions are very uh, robust in nature, very strong in nature. So it's also yeah, 182 members has ratified this convention, as the name only suggests, ILO Convention 182. So here this is about international labor organization. Sorry, this is international legal regime that we have talked about so far. Let's go to the regional regime as well. uh, yeah. um, When we talk about regional regime, usually these regimes are not pan-global in nature, in the sense that they may be very effective, but they are certainly relating to certain region. These are specific to region. And when we talk about this, the first one is Council of Europe Convention on Action Against Trafficking in Human Beings, 2008. So basically, we know that Europe, Council of Europe Convention, Europe, we know that in form of European Union, it has already developed as a like some sort of alternative to state, or a very significant unit of international system, because primarily state was used to be looked and understood as a unit actor. But since the European Union has come up, and with the common currency, with the very least focus on barriers, like in terms of movement of people and all the other practices they do, these sort of regimes which relates to human trafficking or human rights are also very common to the all European Union countries. And this uh, this European Convention on Action Against Trafficking on Human Being, it has been adopted in 2008. It came into force in 2008, because in 2005 it was adopted, but actually it was formalized in 2008. And it builds upon the existing international agreement while exceeding their maximum requirement. So it provides a more robust framework for protecting victims of trafficking. Everyday State Council of Europe has ratified uh, 46. It has been ratified by the 46 members of the Europe. So you see that in a smaller region, almost all Europe has ratified it. So this basically means that it is actually focused on the broader definition of trafficking and in human beings for different purposes. And it talks about the recruitment, transportation, transfer and harboring of the receipt of person, and by means of threat or the use of force or other forms of coercion or abduction or fraud or deception or abuse of power, or 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 a position of vulnerability. So it all achieve a consent of a person having control over the another person. So this is the means, this is the technique and tools through which the trafficking takes place. So basically, this comprehensive international agreement prioritize protecting and guaranteeing the rights of victims, like we have already discussed in the existing international legal regimes. And it encompasses all victims, including women, men, children, and protect them from the various forms of exploitation, such as forced labor, sexual abuse, and physical and mental health. So additionally, actually, it also establishes independent monitoring body to ensure that the participating countries adhere to its provision. So this is one. In fact, the success or the survival of any international legal regime depends on the state ultimately, as I mentioned already. So if states are not contributing enough, if states are not doing enough, it becomes many a time difficult to take the objective forward, because of the lack of any monitoring agencies at the global level. But at regional level, or at in a smaller way, like we know that European Union is highly integrated and very developed also. So their additional establishment of independent monitoring body is it's a provision that is really can be considered as one of the best practices to make the objectives of these regimes workable and more successful. Also, they have adopted a human rights based approach. So basically, this convention represents an effort to tackle human trafficking from a human rights perspective, because it imposes duties on state to take proactive steps to combat trafficking and enact a comprehensive framework to protect and support victim and witness. Victim and witness both here are two constituent, because witness is equally important. Many a times witness turn hostile, so protection of witness is important, protection of victim is important, and to ensure that the investigation and the prosecution continues throughout and to meet its desirable ends. So the convention actually establishes various rights for trafficking victims, uh, such as right to be recognized as victim. It is important, right to be recognized as victim. And see the cultural difference, I would also like to bring here to notice that how particularly in developing countries, and if I may take you to the example of South Asia, here the identity of victim is always it it is efforts are made to hide the identity of the victims, because of lot of shaming attached to it. Recently, I think we were all attending a conference relating to this human trafficking and all, and where we met some of the we could meet live some of the victims of human trafficking, and they expressed their views that how it was difficult for them to be recognized as a victim of those. So many a times they used to hide their identity as the ones who have been through that route and who have been survived. So this is, I think, probably a cultural connotation that is different in Asian cultures and probably different in Europe, because of their too much focus on the human rights and identifying individual as an individual, rational individual itself, and not shaming, and because they see victim as a victim and not the ones who are accused and who should hide and who should be shamed. So their human based approach is the one where the identity of victim should be recognized as victim and receive support, also for recovery from being victim to being normal. This is also a journey, this is also a process, and it requires individual is not enough to do so, because state support is needed, society support is needed, family support is needed for that. So that is a human rights based approach which is there in the provision. And also again, the process of rehabilitation, definitely once victim is identified, once the victim is recovered, in the process of recovery, rehabilitation is the only natural outcome of it. So the convention also adopt a victim centered approach grounded in human rights, as just we have discussed, is it's a victim centered approach, which is a very different from so far we have been seeing that all the existing legal approach at the international level, which usually is a top to bottom approach. It starts from the top agencies, by analyzing the situation from their understanding and coming up with the solutions that they can provide to the problem. But here we can see the difference is a bottom to top approach, looking actually what the problem is and thinking from the bottom's perspective that what actually would work for them. So one can see the difference between the two. It has a comprehensive scope also, because it has a broad applicability covering all types of trafficking and all victims regardless of demographies and circumstances. So it applies to the domestic and international trafficking alike, and whether or not to a connection to organized crime. Convention encompasses at minimum trafficking for sexual exploitation, forced labor, services, slavery, and similar other practices of servitude and organ removal also. So look at their wide, comprehensive scope of this regime uh, to deal, and also it includes all victim of all ages, like men, women, children, elderly, and all. The monitoring mechanism, as I had already discussed, that is one of the significant feature of this regional legal regime, because it adds value to the feature of the convention, because if it is not monitored, if it is not backed by sanction, it definitely is going to be less effective. It definitely is going to be not as strength as strong feature as it could have been in the presence of certain monitoring or certain backup in the name of sanction. So this is from Europe, the Council of Europe for trafficking on human, and uh, then we have yeah, ASEAN. We also know that ASEAN, the Southeast Asian Countries Association of Southeast Nations Convention Against Trafficking in Persons, especially women and children. So ASEAN is also a region which is very integrated in comparison to the. You'll see that if you look at the map of Asia, Southeast Asia is the region which is uh, very developing. Southeast Asia is a region which is integrated. Also, they have their bilateral trade or regional trade as high as more than 48 or 49% of trade. So these are the region which are very prosperous also, in comparison to, you see, South Asia or the West Asia, which is again entangled in their own conflict. And yes, in terms of resources, in terms of per capita income, probably the West Asia will have more money, but in terms of sustainability or also stability in the region, I think they are still struggling to figure it out. So Southeast Asia is definitely the one which is more integrated, developed, and having a very high bilateral trade among at the regional level. So I'll just drink water and then I'll continue. Yes. So the second regional legal regime that we are talking about is ASEAN. And this ASEAN, or in short, we can say ACTIP, trafficking in persons, ACTIP, it also provides a comprehensive definition of trafficking in person and covers all involved in acquiring, transporting, transforming, harboring, or receiving individuals through threat, force, coercion, abduction, deception, abuse of power, taking advantage of a position of vulnerability. So you see that how broad based, how comprehensive the definition itself is. And it also have uh, basically protection and assistance for victim, the provision of protection of assistance for victim, which provides support to traffic victims, including confidentiality and housing. Like, see, when it comes to the Asian region, you see the difference. In Europe, when we're talking about Europe regional legal regime, identification of victim was one of the important segment. But here, when we have entered to Asia, confidentiality becomes important, because of, as I already mentioned, that lot of shaming attached to it. And usually people like to hide identity if they aim and want to go back to the normal route, because with that identity it is very difficult because of the cultural connotation that Asia is having. So this confidentiality, providing housing, providing counseling in case of mental health is not well, and other kind of healthcare, the provision of healthcare, also provision of legal assistance, physical safety. So it calls for the traffic person's view to guide support provision. That this is also a victim centered approach. We see that how it is also a victim centered approach, and it starts from bottom to top, that looking at their situation, understanding, and then coming up with the provision that may work for them in the best of the capacity. So again, commitment to progress. uh, prevention measures means that policies like educational campaign. Preventive measures are those measures which stop trafficking. It has to work before the trafficking takes place. So definitely educational campaigns, making them aware about the problem, and the demand reduction strategies, monitoring immigration patterns, that how people are moving from one place to enter another set of environment. So these are the ones which are preventive measures, and it also required cooperation to alleviate vulnerabilities and mm, like the extreme poverty, extreme lack of opportunity. So these are also some of the points where people are bound to fall to traffic, because they do not have any option. They see that the extreme level of poverty uh, is something which they anyway would like to come out, and in that order, or in that effort, they do not realize that where they may fall. So some preventive measures. Then commitment to progress. Of course, implementation plan, outline commitment, like enhancing data collection. Uh, a lot of data is required, as I mentioned. If a robust policy is required, accurate information regarding data is required. Then only a excuse me. Then only a very sound policy may come up, if a policymaker is having complete information regarding the data. So this data collection is an important thing. Besides this, a comprehensive legal structure transcending national borders, enabling collective action between the member states to counter trafficking is an important approach, because we know that collective efforts is required, and when it is international, the scope is also very wide. But when it is regional, I think it is very cohesive, very near. It is something that is representing a region to, probably, this is my own personal understanding, which might not be true, that nation tends to work more for some for a precise and smaller groups, regional and very close to their affinity, physical or their cultural, or any kind of relation. So they tend to be more active to those groups. So this kind of commitment to problem is included, sharing information with the other countries, going for joint operation, joint investigation, providing information, and also developing a kind of synergy in terms of protecting victim, and also in terms of rehabilitation of that victim. So that, because you protection victim, suppose one person of a particular country or nation is found in another country, so that country should also be equally aware, and the provision should be there to protect that victim and safely repatriate or send it back to the country of origin, where the rehabilitation process can take place. So that kind of synergy within countries required. So these are some of the commitment to progress. Now we'll come to our another last regional legal regime, which is SARC, Convention on Prevention and Combating Trafficking in Women and Children for Prostitution, and it has been adopted in 2002. Before coming to that, I would just like to mention that SARC, as you must be knowing, that the area and the region is one of the least integrated region at the global level. But it is very ironical also, because the SARC is what basically a broader name of Indian subcontinent. Earlier, Pakistan, Bangladesh was part of India, and Nepal is also culturally very close to India, Bhutan for that matter, Sri Lanka, Afghanistan. So the region has cultural affinity at the maximum level. The region has common languages, many languages which is spoken at the throughout the region, and particularly in India, it is there. So there are a lot of similarity within the region, lot of similarity. We have the same kind of food habits, same kind of cultural practices within South Asia. And also the political culture of the countries are same. You see how the political culture we have, the South Asia has not been able to uh, come to a success, to continue to have a successful democratic government so far, except India. If you leave India aside, all the other regions are more or less politically very vulnerable, unstable, and also economically they have huge challenge. Most of them falls within least developed country, and some of them are developing. Many of the states are falling on the verge of being failed state, or at least a rogue state. So these kind of situation, we, why it is important to mention it all here, because we are discussing a regional legal regime which in the region which is very different from the earlier two regions. We see Europe, how integrated it is and how well organized it is, and also in context of Asia, ASEAN is well organized and well integrated. But on the contrary, SARC is almost non-functional. It has not been able to come even close to its desired objectives, and for the reason we all know, the two of the giant countries within the region have not been at good terms with each other for almost since their independence and inception of Pakistan. So this the entire framework, but it definitely probably in, not in terms of economy and not in terms of security dynamics, it has not been able to produce desired results. But then certain other areas like trafficking or uh, uh, terrorism also, I should not say, because it has been an important significant problem that has not been taken up seriously and looked upon seriously. But yes, trafficking, in terms of trafficking, there are some legal provisions. It actually, as a significant as an instrument or to address human trafficking within the member state, it was adopted in 2002 at the 11th SARC summit, and it actually represents a collective effort by member states to combat specific issues relating to trafficking for prostitution, focusing on women and children who are vulnerable, we know. There are certain provisions within it, like the definition of the term, that who constitute child trafficking, what constitute child trafficking, what constitute uh, trafficking in women, what are the threats specific to women. So again, a kind of definitional definitional concepts that has been given to understand trafficking in context of South Asia. uh, some of the articles focuses on criminalizing the all form of trafficking. I think these provisions they have borrowed from, or looking at the best practices which is being followed by the other parts of the world or already existing legal structure. So yes, there are certain articles that focus on protecting and supporting victims. So these include maintaining the confidentiality of the victim, providing counseling, legal assistance, establishing protective shelters for rehabilitation, and repatriation or rehabilitation, the process of rehabilitation. So it also says that this supports and promotes victim-centered approach, and it also look and promotes regional cooperation, because it enables mechanism like extradition, mutual legal assistance, regional task force for the coordination of intelligence sharing, or to indirect trafficking, or harmonizing the national laws with the regional legal regimes. So there are certain provisions that has been given, but the success of this has not been visible clearly, because there are and in fact anyways we'll be looking at that despite existing of the legal, international legal and regional legal, and even at the national level, there are provisions, a lot of provisions in the name of law, and policies. There are agencies to execute them. However, the number of cases in terms of trafficking have not reduced. The number of exploitation, or probably it has increased, and the nature has also changed. It has become more and more exploitative, and the scope has also widened. Now the new area of uh, because of this help of technology, information and communication technology, it has also kind of contributed in changing the entire setup, in changing the entire broader dynamic of international trafficking. So now at the last, I would like to talk about there could be many other legal frameworks at the global level. I have just included here three. There could be many, but here, for our purposes, I had just focused on these three. If we talk in terms of challenges in implementation and enforcement, what are the, definitely there will be challenges, because no law is uh, it is not possible humanly to have law implementation in its complete spirit and totality, because as a human species, or as the scope of the law, human beings which who have a lot of complexities at various level, in various form, diverse form. So definitely, and since this is a topic which itself is a very uh, what should I say, trafficking, and these are the laws which are dealing with the vulnerable categories. So it becomes all the more difficult. So first is the resource constraint, because it is a wide range problem, as we have already discussed, that trafficking is not a, in no way it is homogeneous in terms of problem, in terms of stakeholder, in terms of responses. Everything, it is widespread, diverse, and heterogeneous in nature. So resource constraint is very significant problem, particularly for developing nation, because they do lack the necessary resources to effectively implement and enforce this comprehensive anti-trafficking measures that they plan. So it may be funding, because funding definitely is a very, very important. Inadequate funding hinders the established and specialized enforcement units. It hinders victim support services, and also it provide kind of, it does not give enough uh, resources, or it does not give enough, it does not ensure a proper public awareness campaign, because that also requires a lot of funding. Also it resources in terms of training and capacity building, because this specialized nature of problem requires very trained and specialized people to deal with it. So training and capacity building also require first human resource, and uh, inadequate training for law enforcement, judicial offices, and social workers. They are also not been able to contribute completely to their ability and to identify and investigate and prosecute trafficking effectively. So this is one. Then this nature of complexity of transnational crime, as the name itself suggests, that this nature, the transnational crime, it encompasses cross-border activities, and which necessitates the cooperation and coordination between the nations. So but different legal system in different countries, and the different resource constraints, or different resource availability, and also the bureaucratic obstacles. So these collectively makes it more difficult to uh, implement already existing laws. Uh, Distinct legal framework in the name, like countries having different legal framework, definition of crime, and evidentiary standard. Like what may be very severe crime in one country might not be that severe in another country. So where is the common point, where is the line to draw to come on the similar page? These kind of problems may arise, may come and appear, because human right is something where human right approach also, for some it could be human right, for others it might not be. It might be like uh, some to dealing with some not who is not working in favor of national security or national uh, health. So that way, the difference in terms of understanding the entire structure is important. Bureaucratic obstacles I have already mentioned that it is also because we have been aware, we have also in our daily life we see that how it takes a lot of time. And since it is so complicated and it requires so much coordination with the other agencies also, it becomes all the more difficult to uh, exchange data or to have a partnership uh, in that sustained format, which is difficult. Corruption and weak governance is definitely, corruption is not something which is unique to one country or South Asia or some. Corruption is widespread. It is like global problem. Degree may differ. Some country might be very corrupt, or some country may be relatively less. But corruption is a global thing. But governance, in terms of governance, developing countries are more prone because their governance system is weak in compared to developed countries, and many times they get assistance from and support from developed nation, and many a times because of their own vulnerabilities or limitations, or probably not uh, developed countries might not be interested in contributing. So it happens that way that there's with the weak governance, they just are not able to contribute much in terms of implementation. uh, then weak institution, also weak governance mean weak institutions, like we have been seeing that how if you take case of Afghanistan, I'm just giving it as an example out. It's not out of the context, but probably Afghanistan is a country or is a nation which is where population growth is high. It is booming with the population. And if you look at the demographic sense, from age 15 to 25 or 30, this age group constitute almost 60 to 65% of entire population. So think of that the huge population, 60% of the population is so young, so fresh, and at the same time so vulnerable, because they have not been given right weight for survival. They are, the government there in Afghanistan probably has not institutionalized survivalhood, in the sense that since they are not doing anything, it is easier for them to fall in the hands of this transnational organized crimes, those who are involved in these crimes. So this is a great threat, this is a big challenge. As a region, it is a big challenge, because institutions are weak, because governance is weak. So that is one thing. How to address the root cases? Addressing root cases is actually, it also again look, addressing root cases means empowering the vulnerable people. It means one, it has to be adopted holistic approach, like uh, the comprehensive prevention measure has to be taken to empower people in terms of economic progress, expanding access to the education and livelihood, raising awareness, strengthening social services, ensuring safe migration, and enforcing labor protection. So, however, this catalyzing these systematic transformation requires a sustained resolve and resources and time, and also the result will be visible after sustained period of time. It's not something which can be done overnight or for the period of month or a year even. So this sustained approach is required to address the root cause. A holistic approach is important because without addressing uh, trafficking's wellspring, breaking its cycle is important. It will hit the limit, because trafficking prevention, it should align with the uh, within the broader struggle for rights, development, social justice, if it is to be tackled, cause its core. So this is addressing to the root cause, and then evolving nature of trafficking. So I think, as we also saw and mentioned, that how the nature of trafficking itself has been evolving since the time of 1930s, probably how why people do migrate and where they go and what they do. It could have been for completely different reason, but now society has become extremely complex, extremely interdependent. So all these contribute collectively contribute to the developed nature of, because the added role of information and communication technology. Now to in the name of AI, you see how vulnerable now everyone is going to be with the addiction of AI, with Grok, with ChatGPT, with DeepSeek. A lot of artificial intelligences are coming to provide unlimited information, to provide unchecked or unmonitored information, which is going to be on the table, which can be used positively as well as negatively. So, as I already mentioned, technological advancement and this adaptation of challenges, that the hurdles, actually it requires working at very root level. So this is one, the challenges. So I think for today, I have done for today's class. And yes, just a second. Yes, for today's I have done for the class. I think we have already talked for 1.5 hours. So that's it from my side. So, if you like to give some observation, some addition to this, what we have already discussed, we can discuss it, uh, because the next class probably is also due. So, we can have some discussion. If you have something to share in these regard, what we have discussed, uh, I'm just looking forward.
Madam, thank you so much for nicely explaining the issue.
Welcome.
Hello.
Hello. Yes, yes. You are welcome. You
Madam,
want to add on to
thank you so
something?
much. Thank you. No, I need little clarification. What
Yeah.
are the factors hindering collection of data, particularly even for the legal migration also? Probably northern states are very poor in collection of the data, and Kerala is doing very well. So, what can be the possible factors for hindering the collection of data?
Yes, collection of data. Actually, Kerala is a state which is almost, to the best of my understanding, as I can explain it, and probably other can also give their observation. Kerala is a educated state, and
True.
as I see that most of their migration, almost all of their migration, go through a legal channel, legal pathway. So when it takes place through that route, it is easier to have that data. But in northern countries, particularly if you are talking about North India, many migration takes place many a times through irregular pathways. And
True.
for example, as I already mentioned, the porous border between India and Nepal, between Bangladesh and West Bengal and Tripura and other parts. So also people are not aware, they are not educated, they do not know, because many a times they rely completely on agencies. And agencies, you know the nature of agencies. So how do, particularly if you take migration to the Gulf, it is mostly based on the two factors: the kinship, the one who have already migrated from your family. Particularly, I'm talking in the North Indian region. So they have certain kind of understanding that some known person is there, and then they take whatever channel is providing them a guarantee, maybe true, maybe false, that they will be getting a good job to that. So they just out of hurry or out of whatever you say unawareness, they just fall in those traps. So
True,
this
madam.
could be the one reason, unawareness. And also this taking donkey routes, going to Nepal and then figuring out, and then moving to some twice and third time being migrant. So this could be also a reason that why it is not. But Kerala's migration is very much institutionalized. In fact, there are a lot of, I will also say that it has a lot to do with the coming up with the academia that is playing in for Kerala's migration. There are a lot of information which has been recorded by a lot of academicians. A lot of work has been done, but I think,
Particularly, madam, healthcare and nurses.
and in all, in fact, what is this name? Center for Development Studies, Trivandrum.
No, probably NORCA also,
Yeah,
non-resident Keralite affairs.
affairs. So they do provide, and also those Keralites who have migrated, they have certain very good organization which is transnational in nature. So they do also provide a lot of data and information about the ones who have migrated, those who are Malayalis. So they do have all this networking and record. Probably other parts of the India is still lacking that kind of networking and connectivity in terms of being networked and or being connected at the global level or transnational level.
Thank you so much, madam. Understood, please. Thank you so much.
Okay. So anybody has something to share? If it is question, fine. Even if it is not question and you have some story or some understanding of thing, you can share. And if not, then probably you will close this. So thank you all. It was really nice having interacting with you all. In our next class, we'll be looking at the specific cases of probably US and India, how trafficking uh, is involved into these two countries, and I'll just try to see how I can make it more diverse and interesting. Thank you so much.
Thank you so
Thank you
much,
so much,
madam. Thank you.
ma'am.